Nicholas Haysom is a distinguished lawyer who served as President Nelson Mandela's legal advisor and was closely associated with the drafting of the South African Constitution. He has also advised on several constitutional processes in East and Central Africa, South and Southeast Asia, and he was the head of the United Nations mission in Iraq, advising on the Iraqi constitutional process. It's a pleasure to talk with you, Professor Haysom. Professor Haysom, you were closely associated with the drafting of the South African Constitution. What do you see as the features that you were most proud of in the South African Constitution?
I think all constitutions address a country's history, and I think the South African one was really concerned, even insistent, on establishing, above all else, a new paradigm for the treatment of citizens, one based essentially on equality of citizenship. And I think the process of drafting that constitution committed itself to echoing that call. Citizens will now be treated equally. There will no longer be racial discrimination. But in doing so went, I think, further than most constitutions in entrenching a democratic, essentially a liberal democratic model, but one which pushed the parameters both around human rights, and when I say human rights, I think we pushed the boundaries both in the formulation of human rights, of each human right, to give it then the deepest contemporary reach and fullest breadth of the individual rights, but also in the range of rights which were covered. I think the South African constitution-making experience was one which was very rich and very cerebral, and it really marks it out from others without being immodest. It took place in a context in which there really was an attempt to make the best constitution possible, to take the most recent constitutional technologies, to learn the lessons, to canvass comparative experience, and to try and come up with what we thought was the best product. It's a lesson which I've tried to, not a lesson, it's an experience I've tried to share with others, to build up an excitement about the project of building a new social contract between all the citizens, of overcoming past divisions by creating the best possible terms of that contract.
Do you think that the South African Constitution had too many aspirations, far more than it could actually deliver on?
No, I mean, I think that the South African Constitution really did set out to look at everything that a constitution could do and to try and frame it in that single document. I'm not sure there's much in the Constitution that I would rewrite now, and I wouldn't want to lower people's expectations. It's true that even among South Africans, there were critics of the Constitution who feel it was too elaborate, it promised too much, but if you had to pull out any particular angle, I'm not sure that it did. I think there are some parts of it which are even ahead of its own time, and that will really come into their own only in the fullness of time.
The South African Constitution was presented as a very participatory constitution. But was it truly so, or was it really an elite pact that was validated through participation?
Well, I think it enjoyed the benefit of having an enormously popular liberation movement take the lead in it, and then having taken that lead, go the extra mile to ensure that all the elements outside its own umbrella were also brought in. And I think, quite frankly, from both sides, it's the National Party side and the ANC side, and the process was, although broadly participatory, was really characterized by the leadership of the two principal parties. There was an early recognition that they wanted everybody inside the tent, a recognition that if people were left outside the tent, that they would be disruptive and spoilers. And in South Africa, there was that possibility. So inclusivity was an imperative, not an ideal adopted sort of in a vacuum. I think in South Africa, when we talk about a healthy process, we talk about inclusivity, which means really bringing in the leaders from a very broad range, the broadest possible spectrum, and allowing them to play a meaningful role in the constitution-making process, which also means allowing them to see the parts that they've shaped, to have their own particular aspirations reflected in the text. Which is why when the South African Constitution is adopted in Parliament, it's adopted by 99%. If there is a particular character to that constitution-making process, it is that it was adopted and formulated through a democratically elected Congress. There are some who would want to see constitution-making go broader than the elected legislature. In South Africa, of course, the elected legislature acted simultaneously as an interim legislature and as the constitution-making body. And I've seen processes, and I wouldn't diminish them for wanting to include unelected elements, but South Africa primarily put its focus on having elected representatives, and it did so for a reason, because I think people had been disenfranchised for decades, centuries, and they wanted to see their elected representatives participate and shape that document, rather than unelected civil society. And that really has an important principle in it, which is that it's not just the range of views which go into the product, it's the weight given to majoritarian or very significant parties. And parties which dispense with a forum which gives weight to democratically elected parties tend to equalize all representatives and all civil society organs as each having an equal legitimacy and weight. And I'm not sure that that's always right, and it certainly wouldn't have been right for South Africa at that time.
South Africa is very proud of its constitutional process, but one tends to forget the amount of violence that accompanied the peace negotiations and the constitutional processes. Do you think that it's worth opening up a process when it encourages such a high degree of political violence?
I think we sometimes forget just how violent the South African process was. Not even violent, how insecure we were going through it. It was a real roller coaster. And the early days in particular were characterized by political upheaval and crisis, withdrawal of parties from the negotiations, breakdowns in the negotiations. And it was really only when the parties developed some clarity on exactly how that constitution will be written that a far more collaborative and smooth process evolves. And if I can just mention there that I think the early days and the more violent the period characterized by violence was also a period characterized by lack of clarity on what the process would be for adopting the Constitution. And there were two, in a sense, principal political currents. One which wanted to favor, let us say, inclusivity at the expense of representativity, and I think that represented minorities, not only just the whites, but also the Inkatha Freedom Party, which wanted all parties to have equivalence, and another view which wanted the majority previously disenfranchised to, in a sense, have a leading role and to have the weight of the majority reflected in the process. And those are both laudable. They both have to be accommodated. Constitutions are not just for the majority. But they cannot be to cater just for minorities. And South Africa, we resolved that by doing it through a two-stage process, one which gave greater emphasis to inclusivity, that is the multi-party process which framed core principles, and one which gave effect to representativity, which is the Constitutional Assembly, which then put flesh, as it were, on those principles.
I particularly want to refer to some of the very contradictory promises and aspirations that were made through the South African Constitution. You've promised land rights for all, but you also promised property rights, protection of property rights. Do you think that this creates a conflict and tension?
I think, the lovely and exciting thing about constitutional debates is that they're not simple virtues which you can list. You can't, in a constitution, just run off, we will have all the good things. That, in fact, one right is often in tension with another. And there is certainly virtue in providing some security for property owners, ensuring that property they won't be thrown or ejected from their own property, that it won't be arbitrarily dispensed to as a part of a political nepotism and largesse given to, I don't know, political favorites. There are real reasons for protecting property and safeguarding it. In the South African case, it was quite clear that it shouldn't go as far as protecting the state from rectifying the historical inequities of apartheid and some of the injustices which had been caused. In other words, if you want a property regime which is respected, it has to be based on fairness and justice, which is also providing restitution for those who've been evicted. And so in that property clause itself, you saw a balance between the need to deal with two important imperatives. I think in all constitutions you will see those tensions between equality, in particular gender equality on the one hand, and maybe on the other hand the right to respect for indigenous custom, which may not be predicated on the same notion of gender equality. And how do you reconcile those? How do you reconcile freedom of expression with the right of people to be free from race hate speech? So the South African Constitution tries to find those balances at every point. And it finds them within the context of the debate, the cutting-edge debate on all of those issues, certainly as it was in the 1990s.
Are you comfortable with the fact that courts can also become very politicized and become political actors? Do you think there's too much leeway given to courts to really play an interventionist role in constitution making?
There is, I think, almost a characteristic even of the dark days of our struggle. There was always some faith in, I won't say necessarily the courts and the judges, but in the judicial method of adjudicating disputes. And if you look at the heart of our Constitution, it relies on a promise of rights and the judicial institutions to enforce them. And it was a feature which we, I think, took for granted in writing the Constitution. And it never struck me exactly how central it was until afterwards, when I went to other countries experiencing deep and divisive conflict, or had experienced it, trying to put together a social contract which would bring together the antagonistic elements of society, and finding that people had no faith in the courts, that the remedies which had been so easy for us in South Africa simply wouldn't work in a Burundi, where I was almost immediately after the South African experience. That people would say, well, we're not going to be protected against a genocide by a Supreme Court. In South Africa, there was a real belief that you could guarantee non-discrimination, cultural and linguistic rights through robust courts. And the courts are robust and have proved to be, I think, robust, capable of ruling against the government, respected by the government when they make rulings contrary to the government, and keen and alive to the need that they are the guardians of the social contract. Many of the countries which I've worked since then simply don't have legal institutions capable of enforcing, of playing that role.
Well, South Africa made great efforts to create a rainbow coalition government during the transition from apartheid rule. But is this sustainable? Do you think that you will be able to keep this decade, 2 decades from now?
No, I think that there will always, for some time, that there's going to be a tension. There's real existing inequalities in South Africa, and although perhaps the dividing line is less of a racial one, in other words, there's a multiracial elite and a largely black disadvantaged class who struggle for jobs and that until that finally is resolved, if it's ever finally resolved. And South Africa's not a magical country. It's got to find a formula for resolving those. And the Constitution can't resolve all those issues. It can't proclaim and dictate happiness and equality. It's got to provide the framework within which the conflict over how to get there is resolved. And that's the best it can do. And I think the Constitution does that job. Can I just say on the legal thing and its reliance on the courts, I think that there are some critical political questions which are left to the courts. And left to the courts because, quite frankly, it's not always clear what other institutions would have the legitimacy to be a deadlock breaker or an arbiter. And I think there could be criticism that there's almost too much power given to the courts, particularly in regard to the dividing line between national powers and the powers of the provinces. The courts have a major role in determining which level of government has paramountcy. And very often those issues are intensely political questions. And it does run the risk of judicializing politics and also politicizing the courts. I don't think that that has happened, but I think that that's a fair comment, a fair critique to take on board.
What do you see as the main challenges and pitfalls that are going to face South Africa in the years to come? Drafting a good constitution is only part of the process. It's only part of the story. But living under it is the real challenge.
Well, I think it's over most of the hurdles. It also was a transition which was characterized by a deep commitment to democracy and democratic practice within the movements. And not all the movements which had these transitions in Africa had democratic cultures within the liberation movements. So I think there it starts off with a plus. Will it experience moments of racial tension? Will it experience moments of authoritarianism and so on? That's always possible. At the end of the day, a healthy party political system, real competition, an open society, a strong civil society, which it has, are part of the bigger picture which would safeguard it. Are there guarantees? There aren't guarantees. There never are.
You have been closely associated with the constitution-making process in Iraq. What were the main challenges and pitfalls that you faced in that process?
Well, I think Iraq, first of all, had to engage in its constitution-making process in a timeline which was brutally short, too short. That would have the effect of limiting popular participation in it. But I think much more than that, there was some popular participation in the Iraqi process, but I think you need time. Iraqi is a divided society, much more divided than I had understood when I arrived there. And I think for proper reconciliation to take back, for the proper deliberation, for proper consideration of alternatives, to resolve some of the difficult issues, one needed time, which the timelines imposed, frequently from outside, but also from inside, a kind of rush to finalize the project. What was initially conceived of in the transitional administrative law, the TAL as we call it, as a 6-month process, short in any event, eventually became 6 weeks. And you can't make a constitution in a divided society, making a fundamental transition to a democratic society in that period of time. It also took place in an environment of extreme violence and insecurity, in which at least some of the constitutional draftsmen were assassinated, in which obviously there are limits imposed on popular participation, town hall meetings and so on. So it took place secondly in that context, and that would have an impact as well.
A lot of attention is placed on drafting a constitution, but not enough attention is placed on some of the other issues that are significant: the electoral system design, the way the political parties work, the political culture and history of a country. Do you think national actors and international advisors pay enough attention to this?
I think increasingly there's a recognition that process is important. If you had to look at constitution making over the last 100 years, you can see its shift away from a process in which clever men simply draft a wise man's constitution, or a constitution which meets current imperatives, and there may not even be a referendum, and just be adopted or imposed, particularly in the 50s and the post-colonial period. There's now a recognition that constitutions are not just declarations of sovereignty, the typical post-colonial constitution. they also resolve the relationships within a society. And Sri Lanka would be an example. And that process requires a much more thoughtful engagement by the national society in that project. The post-colonial moment, people were presented as homogenous, as the colonial peoples. 20, 30 years later, they're a highly divided group, and there's a recognition of the linguistic and other fault lines which are simply dividing the society, and which require really almost a re-examination, a rebirth of that country, one which accepts diversity, accepts the balances which are necessary to keep that country together.
Given that social relations seem to evolve even within countries, and context change and the environment changes, can one expect a constitution to last more than 50 years? I mean, is it desirable, or should they be revalidated, renewed, redrafted over in several decades?
I think there should be almost a constant process of constitutional renewal and adaptation, which is not to say that it should be easy. I think one needs high thresholds because constitutions protect the weak as well as the strong, the minorities as well as the majorities, and they won't give protection if they can simply be rewritten by temporary majorities, today's majority. But that is not to say that you shouldn't be attempting to refashion a social consensus and accommodation, recognition and listening to different communities' anxieties and fears. And even in societies which have quite strong fault lines now, and people are really gathering within groups which express particular identities, there's no guarantee that over time that is not going to evolve into a greater class-based or interest-based competition, and so you need to allow for the maturation of the politics in societies.
What role should the courts play in preserving and making a constitution?
I think constitution making is not primarily a legal business. It's primarily a political issue. Where courts have come in, and notably in South Africa, they've come in to validate promises in respect of the process. If you are going to make promises about the process that certain basic principles will be upheld, somebody has to be found to be an arbiter for that. In South Africa, we chose our constitutional court to certify our constitution. Quite frankly, it could be some other body which is respected. We took a great deal of time and care to formulate and to shape our constitutional court as one which was representative on gender, race, region, and so on, so that it would have the legitimacy to be able to make that pronouncement.
But it does leave the role open to political judiciaries and courts that are put under pressure, but this is not something that worries you too much?
Well, it does, and I think one has to take care to insulate the judiciary from those political pressures. I think in general, and I have, as someone who's been in different national settings where these questions have arisen, it really does depend on the legal culture and the strength of the legal culture within a particular society. And once you have that culture, let me use Sri Lanka as an example, a country which I think has quite a strong legal consciousness, legal tradition, respect for the courts. That's only part of the equation. You then have to establish a very real insulation of the court from political pressures, and that is also an institutional, a set of institutional safeguards need to be put in place so that you just don't have rank political influence or rewards or political favoritism in the appointment of the judges.
You referred to constitution making as essentially a political exercise, and representation was very important in this. So the role of parliaments are important in preserving and making constitutions. But what is the dialogic relationship there should be between parliament and civil society in making constitutions?
Well, I think I like to think of, I think you can disaggregate the constitution-making process. I think there's a legitimation adoption which requires elected representatives, finally, to say this is the constitution we want, and to be able to vote on the measures. But how do you come to the draft? Well, there I think is the opportunity to be as inclusive and as participatory as possible, and to actively encourage civil society participation. And I say that because I think it's not enough that it's been democratically adopted anymore for a constitution to have any traction, to have any hold on the population, to compel a loyalty. If you can find a process in which people genuinely believe that their demands, their anxieties have been addressed, that it talks to them in their own language, it speaks to their concerns, that they have helped make the Constitution, then obviously the constitutional product is more likely to hold the loyalty of the populace at large. The constitutional promises, the protections of the minorities on the one hand, and the right of the majority to have their political will expressed, all of these are more likely to be properly respected and sustained if people feel that they participated. It's a product of their own efforts. Now, how do you do that? It's not enough to allow Parliament to draft a constitution and to pass it. And I also don't believe that referendums are enough. I think referendums are a very blunt instrument for popular participation in constitution making. A referendum typically puts before a population 300 or 400 propositions and says take it all or leave it all. And so a much more nuanced approach to participation would really structure a process which brings in consultations with people, town hall gatherings. The one thing I really liked about the South African process was a process of sending out politicians from opposition parties together to go to town halls, stand side by side and say, we haven't come here to talk to you about our own programs, we've come here to listen. And the two of them would simply ask and listen to what people had to say about the Constitution. And of course, and I think in South Africa, many of the politicians complained that the kinds of demands which they were hearing from ordinary people in villages and town halls weren't particularly constitutional. They were just ordinary people's concerns, stock theft, and my husband's not paying alimony for the children, how am I going to get a job? And on the face of it, you may think those are not constitutional issues, but they all talk to some aspect of the Constitution, whether it's equality of treatment, whether it's responsiveness of government, and so on. And I think a process which encourages ordinary people to speak, and then having spoken, feeds back to them what they have said by providing some or other summary of all the inputs which have been made, is more likely, it's not a guarantee, it's more likely to make people feel that they have a process which is listening and listening to them, which has heard them, and hopefully addressed what their concerns are. Of course, when you read a constitution and it's got a page and a half about how you elect the speaker and what happens if there's a tie, it doesn't normally appeal to the ordinary man in the street. But I think that's why charters of rights, for example, which address issues like access to food and education and so on, can go some way in making people feel that the Constitution is a people's charter and not just a politician's document. And just to bear in mind that constitutions don't protect politicians' rights, they protect ordinary people's rights. And when they're subverted, either by the politicians themselves or threatened from outside, it's ordinary people who defend the Constitution. It's not the politicians who man the barricades, it's ordinary people who are going to be called upon to prevent the subversion of the constitutional values which and they won't do it if they don't feel that they've been involved in it, they don't own it.
You know, constitutions have largely been the work of old boys networks and clubs. Not many of them really include women into the constitution-making process or really protect their rights. Have you got any experiences that you can speak of that have been different?
Well, I think the South African one was certainly a positive one. In the first instance, the political party set a rule for participation in the multi-party Congress, which drafted the framework as well as the first constitution. They set a rule that every party had to be 50% represented by women, and not just as advisors, in the front desk 50% voting delegates. And in that process, a very strong women's caucus grew and played an influential role in resolving some of the issues, particularly this clash between equality on the one hand and the right to respect for customary laws and traditions. They were able to bring women across political divides and in that way resolve some issues. And I think to articulate some of the concerns which women might have about family and social rights. I'm not saying that that's a common one, but it's an example, and I use it in other countries to show people that it's possible to go down a route of not only providing for women's participation, but insisting on it.
And do you find that many other countries where you've advised on these processes in Africa and even in the Middle East, that they've been responsive to this?
Partly responsive. They respect, they're intrigued. We've seen situations where women's participation has been encouraged, and even in Iraq, whether from this example or as a result of pressure, there was an insistence on women's participation in the constitution-making process and in parliament. And Iraq is certainly the only Arab country which has a one-third rule. One-third of parliament has to be women. And I think times have changed. I think we're going to see that more and more. I have to say, though, that in deeply divided societies, when one insists on women's participation, you run into the problem of political parties, rebel movements, insurgencies brought in from the outside, who resist prescription as to who should represent them at the table. And they would and want to insist that, for example, leaders of the guerrilla movements or leaders of the insurgencies be at the table themselves. And there doesn't always happen to be a kind of cadre of women party members. There's also an argument which emerged in Central Africa, which in the case of Burundi, in which people argued that you would be favoring one side to insist on female equality or equality of female representation, because the more privileged parties, the more privileged strata, had women who had had access to education and other opportunities, and that even in regard to civil society, that they tended to be drawn only from the elite group, the group which had enjoyed the privileges of, enjoyed the status of a privileged group.
To what extent does the nature of the conflict that a society is emerging from determine the path that its constitution-making process takes? A country that has been devastated by civil war and where communities are shaken up, many internally displaced persons, it's a totally different environment. Is it feasible to see constitution-making, running this trajectory?
The way I would look at it is that where you're making a constitution in a post-conflict situation, best practice is not a choice, it's an imperative. So inclusivity becomes critical. If you don't have all the players at the table, you will have a group out there taking up arms against the Constitution on the basis of its exclusion. If you don't have the broadest possible civil society participation, you won't get buy-in by the people at large. If you don't have extensive discussion and deliberation on the clauses of the Constitution so that you win people over and forge compromises which people will keep to, then the Constitution will unfold. So what I would say is that in conflict settings, you sometimes have to make expedient arrangements in your constitutions to deal with the particular issues of that society, including amnesties and similar things. But it also, in process terms, compels you to adopt best practice.
That's a pragmatic way of looking at it, and I'm not criticizing it. But it does haunt and scar these processes. Can countries readdress this in years to come, and when they feel that there are unresolved issues that continue to haunt communities that are not being happy with these pragmatic deals, is it valid and legitimate to revisit these processes?
Well, I'd put it slightly differently. I would say that the issues which dominate the constitutional dialogue, the terms of the deal which communities need to make with each other in the immediate post-conflict setting, are not necessarily the long-term issues which face the society at large. And it may be that after a period of time you need to reinvestigate the logic, to look at some of the other issues which were simply not on the agenda, the environment, or effective forms of including more marginalized groups which are not at the table because they're not part of the armed conflict. Those issues may need to be readdressed later. I was struck in Iraq where the constitution, the latest constitutional amendment, really requires Parliament, the first elected Parliament after the new constitution, to set up a constitutional committee and to reinvestigate the entire constitutional compact. It was seen as a compromise to pacify the Sunnis who'd felt excluded by the process first time around. But in fact, I think it was healthy practice. It allows you to take a step back, to question some of the provisions. There were clearly issues, I think, which had been forged as a compromise, which on reconsideration needed re-examination. So I'm a believer in constant constitutional review, without a notion that the social contract on which you've basically re-established your new national unity is somehow susceptible to being torn up is not a real commitment. But the notion that you need to sort of re-look at the issues which the country faces can be healthy. It can be a nation-building moment. And I think in many of the post-conflict societies, the real danger that constitution-making poses is that it's a very divisive exercise. It really is part of an exercise in which communities retreat into themselves, articulate their demands as demands against other communities so that they can lay claim on the constitutional negotiating table. And that process of surfacing your identity needs, your specific differences, is very divisive. And some societies literally tear themselves apart in the constitution-making process. So it needs to be accompanied by also a nation-building moment, a nation-building dimension. And that's why I think you need time to do it. You need to articulate that which unites you, not only that which divides you. You need to articulate your common aspirations. You need to recognize in the document that you share a common destiny. And it's finding a way of balancing those two dimensions that's critical.
On the one hand, you refer to constitutions as being nation-building movements. It's also been described as an autobiography of a nation. But increasingly, constitutions are being influenced by international actors in the international community. How do you balance national autonomy with international diktats?
Well, I think the bottom line is to go back to where I started, which is ownership, national ownership of the Constitution, and that's a prerequisite. National ownership of the Constitution is not a cry for kind of what I call national particularity. We don't have to follow what they did there because we are so different, we must find our own solution. And usually those arguments are used for some of the most backward positions. We don't want to have women's equality imposed upon us. It's a Western foreign idea. If you ask women, they don't share that view. You even hear democracy is a Western idea until you ask the ordinary people, and they say, no, it's certainly not a Western idea. It didn't start in the West, and I don't think it should be abandoned and relegated to a culturally specific value. I think, so as a platform, the basics is that it's nationally owned. I think that responsibility of creating this compact really compels you to look around, to see what works and what doesn't work. And you'd be surprised, almost every country is looking at problems which other countries in similar positions have looked at. Even problems which countries in very different circumstances have had to look at. It gives you an opportunity to look at how people have blundered. It gives you an opportunity to draw as I said right at the outset, on the latest constitutional technologies. Now you can, as it were, foreclose on that opportunity or abandon that opportunity, or you can seize it. We certainly seized it in South Africa. We were shameless in taking what we thought was an exciting new way of doing things from wherever. Americas, India, Europe, Namibia, other parts of Africa, trying to find ways of using local custom and customary institutions in strengthening democracy and so on. And thus to make it truly a project which a country can be proud of because you've taken the best available. And that's my approach to it. You have that opportunity. The argument that your country is so different it can't possibly have anything in common with any other country is not right. Which is not to mean you give the right to draft a constitution to foreigners, just as you don't give it to your own wise men. You have to build in, at every stage, acceptance of the constitution by the people themselves.
Thank you very much, Professor Haysom. It's been a pleasure meeting with you.